Good morning and good afternoon. The information shared during this webinar does not and is not intended to constitute legal advice. Instead, this is all information, content, and materials made available for general information purposes. I am Megan Kelly. I'm the Director of Attorney Development here at Paragon. In case you're not familiar with Paragon Legal, we partner with in-house legal departments to provide flexible attorney support. And in that same vein, we are offering attorneys a more flexible way to practice law. Some examples, whether you need coverage for an attorney colleague's leave of absence, whether you're hoping to bring on an FTE hire but need somebody to get in and do the work while you do that, or if you're looking to solve overflow or right sourcing challenges with your legal team, Paragon Legal is here to collaborate with you to get you the support you need from experienced legal counsel. And joining me today is Jenny Sheridan. Jenny started as a corporate attorney. She's worked in-house for several Silicon Valley tech companies. She's served as general counsel for public and private software companies. She founded JLSheridan Law, a boutique firm focused on tech transactions, privacy compliance, and IP counseling in 2014. She teaches as an adjunct professor at Santa Clara University and University of San Francisco Schools of Law. She is an IAPP privacy professional with CIPP US and E certifications. And I couldn't be happier. We are very happy to have Jenny join us again today. Welcome, Jenny.
Thank you, Megan. I'm thrilled to be here, and I enjoyed our initial conversation, and this is going to be a fun one, updates to CCPA, and we've got, I know, a lot to talk about.
Definitely. So yes, this is a follow-up to our part 1 webinar. We did it in May of 2023, and there you provided sort of an overview of the privacy landscape halfway through the year. Some specifics about CPRA's modification of CPPA, and some high-level comparisons to other states' regulations. We foreshadowed our part 2 then, and here we are, January of 2024. Do you want to start by laying out a short overview of what we'll cover today?
Yeah. So first I thought, because it can get complicated, this landscape and this terminology, so I may use this in the talk, so I'll just mention up front that I often refer to CCPA 1.0, which was passed in 2018 in the legislature, came effective in 2020, and it's that statute and the regulations that the Attorney General drafted for that statute that was the subject of the CPRA consent decree in 2022. So that was what I call CCPA 1.0. What happened and kind of overlapped in time was in 2020, there was Proposition 24 on the ballot. So not a legislature, generated statute like the initial CCPA, a ballot initiative. It passed. And what it did was pretty extraordinary. Was at first it called for a new agency, kind of the first of its kind in the United States, the California Privacy Protection Agency. So that agency had to be stood up. It was given the mandate also to write the regulations for these new changes to CCPA. So like CPRA that you referenced, that was the proposition initiative. But it basically just modified CCPA. So now I refer to CCPA 2.0, which is, again, the modified version. That has been complicated because it was, again, a lot for a new agency to do. So what they did is they divided into what I'm calling Part 1 regulations and Part 2. And so they worked on what they thought would be the easiest to do first, Part 1. That's what we talked about last May, and I'm going to do a quick review of that. And then those became final March 30th of last year. I'll talk a little bit more of that in the update. But then part 2 is what we're going to talk about more today. These 3 areas of regulations: risk assessments, cybersecurity audits, and automated decision-making technology rulemaking. So those 3 areas that are still in the draft stage, but we're going to talk about, there's a lot of substantive stuff to talk about related to that.
Sounds like we have a lot to cover. So let's dive right in with the short refresh on where things stood when we left off at part 1.
Sure. Okay, so 5 things I want to hit on kind of our review. And you might, those of you that were on the May conversation, remember one of my themes was GDPR is coming. We're seeing that in the concepts of the new CCPA 2.0 and many of the other US state laws as well. But the first thing that you need to do to be sure you're up to date is, have you added the right to correct on your privacy policy? What we did with CCPA 1.0 is you have the right to delete, the right to access, portability, but there wasn't a right to correct. So as I say, when I'm reviewing for clients, that's an easy check for me to see, hey, have we updated that and have that right to correct? Second, you have to do your CCPA analysis if you're selling, and then now we have sharing. So CCPA 1.0 just talked about, are you selling personal information? That was the subject of the consent decree with Sephora, but not coincidentally, a lot of what CPRA was about was to be sure, no pun intended, that the advertising industry was targeted. So that's why they added this definition of share personal information, of a definition of cross-contextual behavioral advertising. So to make it easier for businesses, you can have one opt-out link that says, do not sell or share my personal information. So hopefully you've already done that analysis to see that you are subject to it. If you haven't, you need to do that, and then be sure you have that on your website and it's operational. Third is you need to review for sensitive personal information. This is a new category, kind of like Article 9 of GDPR. It's also, we're seeing it in the other US state laws too. So there's that slide that we went through all the different categories of sensitive personal information, biometric, geolocation, several things. There's overlap with other US state laws, but they're not a perfect match. So you need to look at that. Then what you have to do if you're in California is see if one of the exceptions applies. So we talked about that last May. Like if I am offering genetic testing, I need that sensitive information to provide the service. But that doesn't give me the right to a secondary use of that information. So if you're not in one of the exceptions, then you need to put on your website another link called limit the use of my sensitive personal information. So that's third. Fourth, one of my favorites, but are you a covered business? And I've written about this, a couple articles in IAPP about it, because I represent a lot of small, medium, privately held companies where they don't even have the people infrastructure to, again, manage a lot of this regulation. So one of the things that I thought was really significant in the modification from CPRA was they changed one of the threshold definitions. Now, there's the 25 million, okay, like if you're there, you're in, are you a data broker? But if you're not in one of those two thresholds, then you look at the number of personal information records. And CCPA 1.0 said you buy, sell, or receive 50,000 of these records. Now, a lot of the commentators at the time said, receive, that's like hits on a website. So, you're in like every website business. So that's, again, and I was advising clients, better not to have a negotiation with the Attorney General, right? Let's just get compliant. But what happened with the modification was now it's buy, sell, or share 100,000 records. Buy, sell, or share are all defined in the statute. So again, as Megan said, we're not giving legal advice here. You need to do your own review with your attorney. But if you're a B2B company, you're not doing cross-contextual behavioral advertising, you're well below the revenue threshold, maybe you'll take a risk-based approach that CCPA as modified doesn't apply. Fifth, employee notices. I keep mentioning this over and over, even to friends and family that have businesses. California now covers all personal information. If you're a covered business, right? Okay, if we're in, because we're a covered business, it's B2B, B2C, and employee. That's not the case in these other US state laws. But this is more similar to GDPR. Again, that theme, GDPR coming. So when we get into some of the interesting conversation today, we'll see how significant that is that employees now are covered. But my last thing to mention there is be sure you have given your notices to your employees. The Attorney General did say that they were sending out letters to larger companies asking, have you done your notices? Now, those won't be on your public website. That would be, again, you'd notify your California employees. Some companies may decide to do it for all their employees, not just California. That's a business decision, right?
Wow. Yes, we covered a lot. And I remember we left off at a little bit of a cliffhanger because there was this upcoming meeting with the CPPA. I know that meeting got postponed, which carried our webinar here until in January. It took place in December, mid-December. What is the status now? Where are we at in the process?
So I think it's worth for all of us, because as advising clients, whether we're in-house or outside, to kind of have an understanding of this process. And this is what, remember when I said part 1 regulations have already gone through this process. So we're going to go through it now. But the agency drafts regulations that the board approves. And then when the board approves them, which again, the ones we're going to talk about today haven't got there yet, but the agency publishes a notice of proposed action in the California Regulatory Notice Register. And then that triggers this 45-day comment period. So if you want to make comments, get ready to do that. Now, the agency may call an open hearing. They don't have to, so we'll see. They also may provide an additional 15-day comment period, especially if they've made some changes based on what they heard during that 45 days. So that's a couple months we're talking about. And then the really laborious task that the agency has to do is they produce something called the final statement of reasons. So they have to look at all these comments and draft this document that responds to them. And then once that's all done, and again, so I would say that's at least a couple months, then the agency sends this final rulemaking package to the Office of Administrative Law that has a 30-day review period. As I understand it, they just make sure that cross-references are right and it all looks good. But the final effective date isn't until the OAL concludes their review. So we're talking 3 or 4 months. You know, the word on the street kind of is, well, we didn't get final rulemaking in the January meeting. It was more about budget and strategic vision. The next meeting is not announced yet, but is supposed to be March. So if we do have, there's 3 of these. Now, again, they could go staggered, but let's just say they all go together, the 3, they have them ready for final in March. Then, you know, we're looking at probably this summer to fall of them being final. Now we have just mentioned this Sacramento Superior Court case. The Chamber of Commerce brought suit on those Part 1 regulations and said, this isn't fair to business. We don't have enough time to prepare. So the court actually agreed with them and issued an injunction giving a 12-month grace period. So those Part 1 regulations aren't effective until a couple months from now, you know, end of March 2024. The agency has appealed, but as far as I know, it still stands. And so we could say that, again, these rulemaking, if they become final this summer or fall, we probably have a year. Now, what I'm going to say is we're going to talk about over and over, you'll need it. You know, you'll need it. I mean, most companies, you'll need it. So don't, in other words, the message is don't wait.
Don't wait. And with that, let's dive into sort of the meat, the substance of these regulations talked about coming out of the meeting in December. Where do you feel the best place is to start, Jenny?
Yeah, let's start with risk assessments because
Okay.
those draft regs too we got at the September meeting. So at a high level, any CCPA covered business, I remember we talked about that a minute ago, but are you a covered business? You must conduct a risk assessment if you engage in high risk processing of personal information. And what I think is interesting so far, and again, I'm going to keep saying this so far because this is as of December 8th, those draft regulations, that again, they're drafted by the staff attorneys and then have to be reviewed and approved by the board. They include a requirement for an abridged summary to be filed annually with the CPPA, sorry, the agency. That, we don't even see that in Colorado. Colorado that also has regulations. It's upon request of the Attorney General. I think you have 5 business days, which as we always say to clients, you can't wing it, you got to have it ready. But the California may have this filing requirement.
And remind us again, Jenny, what is considered high risk processing?
Yeah, so that we've all been focusing on. So definitely if you're in this world of selling or sharing personal information as defined by the statute, you know, targeted cross-contextual behavioral advertising, you need to do a risk assessment. I've already started that with clients. Sensitive personal information, again, you need to do a risk assessment. The one that's going to be very interesting, we're going to talk about quite a bit, is automated decision technology. So that is going to be a big heavy lift, because there's not only going to be the requirements of the risk assessment, but there's a whole nother set of requirements just for ADMT. The fourth one, consumers under the age of 16 that the business has actual knowledge of. And again, as an attorney, we like that actual knowledge. That's a more business-friendly standard. Now, the next two, these are ones that there was quite a bit of discussion by the board about, because these could be, again, complicated for certain businesses. Processing personal information, processing personal information using technology to monitor employees, contractors, job applicants, students. And they give very specific examples. Keystroke loggers, productivity or attention monitors, automated emotion assessment, facial or speech recognition or detection, location trackers. There are a lot of businesses that are already doing this. I mentioned to Megan, I just saw an article yesterday. Now, this was in Europe, but they're a big US company. Amazon got hit by a fine by the French authorities for violating GDPR. And remember, like I said, California, you could say, is following GDPR now, that employees are included. And the authorities in the EU have been sensitive about this issue for some time, surveillance of employees. And the way that it was talked about at the board meeting was, is this intrusive employee monitoring? And in fact, I think the article said that the French authorities called it excessive intrusive employee monitoring. Think about, like, you're working in a warehouse holding a scanner. You're being timed to this millisecond, I guess, of how long it takes you to scan something. So this is, again, a real issue, and I see it coming to California. And then the last one where you have to do a risk assessment is processing personal information of consumers in publicly accessible places. So I think of, like, the shopping mall. You're using the public Wi-Fi, they're watching you, tracking you. Hey, can get $20 off on this purse if you go next door. I mean, that kind of thing. So again, it's not saying you can't do any of this, but again, there's going to be more regulation of it.
Interesting. The employee monitoring first sort of rang to me about the remote work versus on-site work conversation that's constantly happening, and how employers might use that technology. But I didn't think about sort of the scanner situation too.
And I was just going to add, I encourage people, I think in the sources we give the references to the regulations, because wherever they have examples, I mean, that I really, think that's really helpful. So they gave several examples of when you definitely have to do a risk assessment, like ride sharing provider using automated decision-making technology for making decisions about their employee drivers for fares or bonuses. Think of the mobile dating app that's processing sensitive information about ethnicity or sexual orientation. Got to do a risk assessment. Behavioral advertising. But a lot of this monitoring, whether it's of employees or the public, grocery chain, they gave examples. So there's a lot of those kinds of businesses. If you're in those type of businesses, you need to really start thinking about your risk assessment.
Yeah. And so with these regulations, there will be requirements in how the risk assessment is completed, or what constitutes a valid risk assessment. Is that right?
Yes.
Okay.
So that's what we're looking for. I mean, what we have right now is kind of a checklist of here's what they expect a risk assessment to address. What and other commentators are saying this too is we're going to look to DPIA. If you've been doing the data privacy impact assessments under GDPR, you've definitely got a leg up. First of all, you've just got a process, right? Like if you're a company that's been doing those, you've got a process for doing it. So there's a lot of overlap, and I'd say even heard the board say, let's be cognizant of that. I think other states are too being cognizant of it. Like, let's not excessively burden businesses to do totally different assessments for different jurisdictions. So there's a lot of overlap. I think one thing that I know in the GDPR they care a lot about is necessity and proportionality. I don't see those terms, but here's what I see. You got to start with a summary. What are you doing? What are the categories of personal information being processed? What's the context? What's the reasonable expectations? Then you start getting really detailed, which is going to involve a lot more information gathering. Operationally, how many consumers are affected? What technology is being used? Who? What are the names of service providers or third parties you're sharing the information? And if you don't want to provide the name, why? You've got to justify that. The purpose, benefits. Then you get into the typical DPIA, kind of I call risk mitigation analysis. So identifying the risks, like, it's a data breach. What are you doing? Encryption, de-identification. Those are kind of standard protocols, often referred to as guardrails. Are you doing those? So that's pretty typical. What there was a lot of discussion about at the meeting was they kind of copied this, it seems, from the Colorado regs, but these negative impacts on privacy, and they are broad. I mean, they go from constitutional harms to psychological harms. I mean, I don't think even the average attorney or privacy professional, would have enough background to do that. It's going to be very challenging. Now, one thing I know, because again, as lawyers, words are important. So one of the things, and I think this is why the board was having so much discussion with the staff, is there's a little difference between the way Colorado looks at those negative harms as a requirement and the way so far the draft is for California. Colorado says you may include consideration of any of this list. Okay, may is very permissive, right? Well, we like may. Right now, the California regs say at a minimum, the business shall, again, shall is very different, shall consider the following negative impacts to consumers' privacy as applicable to the processing activity. So what that says to me as a lawyer, if I'm advising, is we can't just skip over this, right? We have to do, and I'm going to mention this a couple of times more, documentation analysis, documentation. So there's definitely, as they stand right now, and again, they might get modified, a big burden there, right? One of the other things that came up was the California Age Appropriate Design Code law. And the only reason I mentioned that is because it was mentioned in the meeting. That is supposed to come into effect July of this year. It's largely based on the UK one. There was a challenge to it, and the lower court actually issued an injunction. It's going up to the Ninth Circuit. But I'm not an expert on that law, but what the board was even talking about is they thought some of the discussion arguments there could be applied here to some of these negative harms. So we'll see. I'm waiting to see what happens in March, if at least maybe this language will become more permissive like it is in Colorado.
Yeah, that's a lot in terms of the risk assessment sort of parameters. You mentioned at the top, another topic we'd cover today was cybersecurity audits. In my mind, audit and risk assessment sound very similar. Is there overlap here, or what is the CPPA talking about for cybersecurity audits?
So cybersecurity audits get very technical very fast. And as a privacy professional, what we'll be doing is guiding our clients, like, do they apply? And so we'll see again if this shifts at all, but it seems like what they've settled on is a two-prong. So the first prong is you have to be the 25 million or more. Because remember, like a covered business, that's just one of the prongs. You can be under 25 million and still be a covered business. So for the cybersecurity audits, you have to be a 25 million revenue threshold. Then you also need to be processing one of three or more of these types, the volume and type of data. So if you are a 25 million or more business and you're processing the personal information of 250,000 customers, very likely if you're already that level of revenue, you're in. If you're processing 50,000 or more sensitive personal information records, you're in. Or personal information of 50,000 or more consumers that the business had actual knowledge of under 16. So that's the way it looks right now, that And the other key question, like we're thinking about as lawyers and advisors here, is who is going to conduct it? So right now it says that it has to be independent, but it does claim that you can be internal if you can meet the definition and criteria of independent. So, should take a look at that in detail, but I'll just quote one of the excerpts here. The internal auditor cannot participate in activities that could compromise its independence. The internal auditor must report directly to the board or equivalent. So as a lawyer, I'd be saying, again, analysis and documentation, right? Like if we think, and there's probably companies that can justify it, it reminds me of like the GDPR data protection officer requirement. Again, can you prove that it's independent? But for most companies and a lot of my clients, they're not going to be able to do it internally. They're going to have to look externally.
And when it comes to the audit itself, or do we have guidance on what's required when it starts?
Yes, so that is pretty extensive. It's like 3 or more pages in the regs, the controls, 18 specific technical and organizational safeguards. And there is some language that says if you don't have them, explain why they're not applicable. So again, it's kind of like what I was saying with those negative impacts. You can't just ignore it. You're going to have to go through it with an expert. And this is, again, where the average attorney is not going to be able to do this. Okay, you have to have, whether it's internally or externally, a security consultant. What I like to quote from here is Rick Borden, that's at the law firm Frankfurt Kernet. He has a couple published blog articles about this. He has a lot of experience in New York State with their requirements. And one of the things that he really pointed out as kind of a very difficult bar for most companies to meet was the zero trust architecture. He quotes NIST, the National Institute of Standards of Technology, of calling zero trust architecture a journey, which I guess in data speak means very, very hard to meet. So again, you can make your argument for why you shouldn't have to, again, meet that requirement, but it's going to take quite a bit of work to go through that. And I assume, there's already people that can do that, but there's going to be more and more consultants helping with this. My other thought about this is, if you have SOC 2 or ISO certification, right, like many of my B2B clients now do, that's going to go a long ways, toward being able to do this. But again, for companies that don't have that or haven't gone down that path, like I have, B2C clients that could get, because of their revenue and their processing, are going to be subject to this. So one of the things that they're doing is they're saying the initial audit would be 24 months following finalization of the regulations, and then every 12 months following. So that is good because you're going to need that time. And that's my message. If you fall in this, look this year, 2024, for your, again, especially small, medium companies, you're going to need external help. Because if you wait till next year, again, it could be very difficult to even find help because, again, it's going to be a cottage industry there.
Wow. Putting a bow on the cybersecurity audits and moving on to automated decision-making technology. Everyone's talking about AI. California's at the center of those conversations. What is the CPPA talking about in terms of this overlap between AI, ADMT, and privacy?
Yeah, so I think this is one where we may, not see it ready right away in March, but because this is an area that, is more new. California, we're taking a lead here, but where I start from is, who's covered. They've taken, we've been following what's happening in the EU with AI regulation. They seem to be taking even a broader swath than that, talk about in whole or in part, facilitates human decision-making, any technology. So they start with this very broad swath. And then what you're looking at is it being used to make decisions that produce legal or similarly significant effects. So the areas that are obviously going to get caught up in this are making decisions about employment, loans, finance, insurance. I say, is there a financial or health effect for a consumer that's being made with this? But I think one of the things that they want to try to capture is just AI that's being used with minimal human involvement. So not to like avoid that. And it also includes profiling, evaluation, preferences, employee productivity. And if you are in this universe, then what is going to be required? Risk assessment, a pre-use notice, and opt-out right. You're going to have quite a bit of work to do.
And there's that risk assessment term again. For ADMT, are we talking about something different in terms of a risk assessment than the high risk processing risk assessment we covered?
Yes. So,
Okay.
I mean, this is going to get much more technical. I mean, this is really going to be a cottage industry. Like they have published, again, like several things that they want, again, a business to have to think about. You're really, again, going to have to not only like justify what you're doing, but how you're doing it. Like it talks about what's the logic of the ADMT and its assumptions. But then here's going to be a really important kind of cottage industry. Have you evaluated it for validity, reliability, and fairness? Because I think this has, been kind of reported about, but that Amazon had like stopped using some ADMT that found that there was fairness issues. So that's going to be probably, again, a cottage industry to look at these and see, what can meet that test. But you are going to have to, again, not do this in a vacuum. The degree and specifics of human involvement in the business's use of ADMT, including detailed requirements for the qualifications of the involved persons and how they can influence the output. And then safeguards, like again, it's a typical risk assessment, but you're going to need some really technical help, I think, to be able to do this satisfactorily. And, and then again, do the just similarly to like what we do in other kinds of risk assessments, what are we doing to mitigate and protect against those? But if you are in this world, you're going to have to, meet a huge test. And I'd imagine for a lot of companies, they're going to look to vendors, right? But then they're going to need to be sure that the vendors are meeting all these requirements. Or like me as a contract attorney, I'm always like, what are your reps and warranties and indemnification, right? And are they carved out of limitation of liability? Mm-hmm. So again, if you're using these kinds of tools, be sure that you're thinking about that.
Yeah. And this is another just great point, given the amount of information that we have and you've shared in your PowerPoint for people, that this is outlined in the PowerPoint available in the documentation area as well. Okay, so we've got the risk assessments for ADMT, and then you referenced pre-use notices and opt-out rights.
Yeah, so again, right now, and again, I keep saying that these aren't finalized, but here's what they are talking about, what it should look like, is you first need a plain language explanation of the purposes, and they very specifically state, this is really to lawyers, I think, cannot be generic like improve our services. That's one of the discussions we have still about privacy policies, getting more specific. And I think, as a lawyer, I don't have any problem with that. It's just that I want to make sure that we can support it, right? And its accuracy. And as we know with businesses, things change. So that's, clients don't like to hear this often, but already in the privacy world, we're finding things have to be maintained and checked and updated. Like they can become stale very quickly. So there's going to have to be, again, if you're in this world of the ADMT, there's going to have to be some thought. And again, we'll look to best practices. This is where I think associations and organizations help each other, like IAPP, like let's talk about what could be a good approach to this, because this is all new, especially for the US. Then second, you have to have a description of the consumer's right to opt out of the business use. And we, again, if we'll talk about that in a minute, but exceptions, you need to talk about that. Why do you think as a business you have an exception to that opt-out? But again, consumer needs to see this. And then other things they talk about is having a description of consumers' right to access information about the business use of the ADMT, including information about how the business uses the outputs, the role of human involvement in the business use, evaluation of the ADMT for validity, reliability, and fairness. That's a whole, I think, cottage industry in itself. The logic of the ADMT and information related to the outputs. Now, think about, if you're using this in a public space, very likely, maybe you're going to have like a QR code that you can scan. And what I foresee, just like we have in privacy policies now, I follow the best practices that regulators have said about layering, like make things as clear and understandable to the consumer. So have layering. So if they want to know more about cookies, they can go to this link. So I think that's what we're going to see. In California, we already have Proposition 65, where we have to notify about harmful substances and things. And you don't have a huge detail like in the store or whatever, but there's somewhere I can go and get more information if I want. So, that's what I see. We'll see again with this ADMT. They call it pre-use notice. So let's emphasize, why is it pre-use? That means you're supposed to notify before the consumer is using it.
Okay. And anything else before we move on the ADMT topics we touched on?
Yeah, so the third stage of this, I would say, is, okay, the opt-out notice. What are the exceptions to that? And this is where, at that December 8th meeting, those of you that participated, you probably saw there was a lot of discussion, and I would say back and forth between the board and the staff attorneys, because remember, that's how it works, is how these regulations are being drafted. Staff attorneys are drafting them, and then they have to have an open public discussion with them. So this is where a couple of the board members had a lot of questions about the breadth of this, of how much this covered, and the narrowness of the exception. So they have exceptions for using it for fraud, security, protect the life or safety of a consumer. The other exception that a lot of businesses are going to be looking at is provide the good or service specifically requested by consumer. Now we kind of remember that with the sensitive information. If you are, again, like genetic testing, I need that sensitive information to do it, right? It's kind of a more straightforward exception, I'd say. What I see here is the staff drafting this is wanting to make sure, I guess, that you're not taking advantage of this, but says, provided there is no reasonable alternative to the business. So this is going to really mean I would be advising business, you have to do an analysis here. Here are some of the things in the draft regs. It would be futile for business to develop or use alternative methods of processing. Use of an alternative method of processing would result in a good or service that is not as valid, reliable, or fair, or developing an alternative method of processing would impose extreme hardship on a business. So that's where we get back to analysis and documentation, right? And I guess this is a theme I'm going to bring up a couple times, is this is where I think businesses need to look to their industry associations and coalitions, especially small and medium-sized businesses, to give them support, because this, is going to take, I think, a lot of work. So basically the way I see this is, and this is in the materials that we're providing, there's a rebuttable presumption that the business has a reasonable alternative if there is an alternative method of processing that has been used for a similar good or service. So we think about that as a lawyer here, and I'm not a litigator, I'm a business attorney, but still, that means to me, we got to do some due diligence, right? We can't just say, oh, we had no idea. So that's, again, where I think trade associations, and that is going to be helpful for businesses. And the final note on my slide there is there's no exception for behavioral advertising. So this is where I see that there's going to be a lot of focus by business, is can we, fit into this exception for the opt-out notice? Because that's, again, a lot of logistics and work and stuff if you're, using ADMT.
Yeah. This has been a great outline with a lens towards the future, helping our audience sort of understand, these things may not be hard, fast, final yet,
Yeah.
but they are going to be time consuming. You are going to need to conduct analysis. You're going to need to document, and you're going to need help, whether that's attorney help, technical professional help, and a collaboration across the industries, like you were just saying. What else was noteworthy coming out of that December meeting as a fly on the wall there?
Yeah, so the first thing I think is a really hot area that, again, as a business, you should look at, are you doing any employee monitoring? And, like what is going to be the scope of this definition of intrusive employee monitoring? So I think somebody mentioned electronic monitoring, like badge attendance, so I'm waiting to see what comes out, because like I said, I think with the ADMT, there may be more revisions here. But the next thing was this question of the negative harms assessment in the risk assessment. There was, again, a lot of pushback about that and the interplay with the California Age Appropriate Design Code challenge. So I guess I'd say, again, a little bit wait and see. But, this could be, again, that could be another area where, again, trade associations, industry associations can help with all these types of businesses. Here's our approach on those negative harms. And, what's the economic impact of these? That's what the board asked. So we're going to see that too. They're going to give us, I think, some figures on like how many businesses are affected and what's the cost to comply.
That's critical information that will be helpful, hopefully. Before we turn to questions or wrap up, one of the favorite parts from our May webinar for me, and we received feedback on this, was the context provided. It was in the context of a B2B SaaS company and some practical sort of insights. Are there any use cases or practical insights you can share relative to these takeaways?
Well, I think first you need to look at your business, right? So if you, again, in the ADMT world, are you in a business where it produces legal or significant effects, right? So like things that affect people from a financial or health perspective. Like I look at some of these cases that are happening where health insurance companies apparently seem to have been using AI without human involvement to make decisions about treatment. We can all feel like that's one area we'd like to have more oversight, right? But if you're in a business that employment, financial decisions, take a close look about how, and what I hear over and over too is, we're all using this in one way, either directly or indirectly, right? Either our own, we've developed it, or more likely we have vendors now that are using it. So you really need to kind of do at least a general assessment. But I would start with, are you in those categories of, again, having higher risk? And then are you doing any employee productivity monitoring? I mean, that's, again, something that's, again, what the regulators in California seem to care about, right? Mm-hmm. And what I see is going to be tougher for the smaller companies, but if they are within the cybersecurity audit thresholds, we're going to have to get consultants. Risk assessment, again, for especially automated decision-making for small companies is going to be tougher. And yeah, we're going to have, again, it's going to be full employment for a lot of consultants.
And what are you, and what can you share with us that we should be keeping our eyes out for as this year progresses?
Well, so I think that first you should do your overview. Make sure you're caught up with what I call part one regs, that if not enforceable now, they will be, very shortly, like all those things we talked about, and they're on the slides too, but all those updates, employee notices, are you using sensitive information? Do you have your updated opt-out link if you're selling or sharing information? And then getting ready for what's coming, and why I'm really saying I think you need to start now is, like, look at risk assessments. Are you possibly doing this high risk processing now or likely to, you need to start getting ready now. Cybersecurity audits, again, if you're not a huge business that can justify the internal audit, you're going to have to look for a provider. And the automated decision making, again, that's a lot of documentation, especially if you want to take advantage of the opt-out exception, is to do that. And I think, I've been really thinking more recently about this thought about how can organizations, support each other. And in my research, I found something people might be familiar with, the IAF, the Information Accountability Foundation, but I found something from last year. They called it the Colorado Project, where they mentioned the California regulations coming too, that they were going to try to, again, support a framework for, again, discussion, analysis, and recommendations. And I think this will be very helpful for smaller companies, because this is just, going to be, and we know, I love Silicon Valley. What I love is how small companies can do a lot and have an impact. But they are obviously always sensitive about the regulatory burden. And there's no question, this is a new world.
Yeah.
This is a very new world. And I think you might remember last May, I had one of my themes was GDPR is coming.
Right.
And so, we see that so much here. And I am sure that the agency here in California is very well aware of and you have all these different authorities in the EU and UK, but what they're thinking about this and what they're doing. So that, I want to see the positive of that. Maybe there'll be coordination, because my clients, even if they're privately held, are global. Right. They're tech companies, they're global. So they have to be compliant with all these regulations. But the one thing I'd want to leave audience with is remembering what is unique right now about California is it includes B2B and employee data. Mm-hmm. We are not getting into the other state laws that so far are focused on what we call B2C. So, yeah.
All to come, I'm sure. And again, I'll just note the written materials are in the GoToWebinar interface. Included there, Jenny has been kind enough to share lists of resources that you can go to read up more on what's been shared today, in addition to the PowerPoint that we've provided.
Yeah, I really recommend those. Yeah, there are a lot of articles, and then it should be references directly to the draft regulations, which, like we said, we've got to wait and see if those get changed very much. What I imagine is going to happen typically just before the meeting, they drop things. So
they don't want to give everybody too much time.
Yeah. So
okay, great. Well, we have a little bit of time left here today. If you have questions in the audience, we invite you to please drop them, excuse me, in the chat. One question that's come up here that I think would be helpful, or what is going to be helpful from the regulators, from the CPPA, for businesses to become compliant?
Sorry, what is going to, sorry, say that question. It seems very broad.
Yeah, it is. In terms, they're going to give us the rulemaking guidance, but what else is going to be helpful here in terms of resources for companies to get on the same page?
Well, I think that's where, organizations like IAPP, play a great role. And again, if you're working in this field, you definitely should be involved with IAPP. What I like too about the organization is it operates at the international, the national, the regional, the local level. So they are constantly doing different events. Also, we've got in California, we've got the California Lawyers Association. They have a conference coming up in February. So if you're practicing in this area, get involved with these organizations. That's my, I guess that would be my main recommendation, is There's plenty of opportunity to talk to other professionals. And remember, in this area of privacy, there's a lot of us who are attorneys, but there's non-attorneys too, because there's a lot of privacy professionals that have been working in this area with, because we've had regulation and HIPAA in the finance and health area. So there's a lot of folks who are very knowledgeable. We're very knowledgeable about GDPR that aren't attorneys. And so just, get involved in this community. It's a great community.
Do you anticipate there will be like templates provided or shared, or is that something the industry is going to have to come together to build on their own?
That's a good question, because I was thinking about that recently, like ICO, the UK's authority for because again, now, with the split, we've got the EU GDPR and we've got the UK GDPR. And so the ICO authority, I think they've been very helpful in that respect of giving suggestions. And so I haven't seen that coming, but that would be great if we could get that, especially for businesses. Definitely need that help, because this is all such, new territory.
Right. Another question is, oftentimes with California and employment law, companies or lawyers can operate from a place of, well, if we're following California, we're pretty safe everywhere else because California is so restrictive or has the most restrictive regulations on the employment law front. Is that the direction we're going here with privacy?
Well, what has been interesting, like with the sensitive information, there has been kind of like a split. Like California has gone for this opt-out, and whereas the other states have an opt-in. So again, the general rule, if you're looking for a national standard, go for the most restrictive. So if you're in the consumer space, like my B2B clients, so far, they could avoid these other laws because they're focused on the B2C. So, and then for some of my B2B clients in California, they might make, I call it the risk-based analysis, that the revised new CCPA doesn't apply. But if you are, again, a B2C company, yeah, I think that it's going to be a good thing to take a look at.
Right. One other question, we've said throughout today, there's going to be a lot of work coming down the pike one way or another. This individual's offering that they have a lean legal department, 3 people. They rely on their outside counsel really for privacy help. Are they relying on outside counsel for this? Who do they need? When? Does interim support come into play here?
Yeah, no, I definitely see, again, for this risk assessments, to set up a framework, it's probably going to be very useful to have contract in-house help, right? To set that up. And then you can work with people, again, cross-functionally. And I think that's one of the things that I actually enjoy about this practice. Like when I work with clients, first I start with, I call level 1, like let's just see if your external facing notices are compliant, because that's what the regulators are looking at. I tell them that's the first place you're going to get tripped up, right? So is our privacy policy accurate? And that's not a 2-hour job, because I need to know what you're doing. I have a whole questionnaire. But all of this is still level 1, and I basically give them an analysis, attorney-client privilege memo about their practices. Level 2 is starting to do those internal practices, right? And so that takes more time, people time, and a lot of it, it's almost like project management. So that's where I see bringing in the contract attorney who's knowledgeable about that can help you set up that process. Like again, you could first have, again, outside counsel help do the analysis. Like, are we in on these things? If it looks like we are in, then some contract help to get the infrastructure set up. But what I find is, you've got to work with IT, you've got to work with marketing. That's all these different, and people are people. So I won't want to make any, statements about any groups that are harder or easier to work with. It really depends on the people. So that's why I think people that work in this field, it's good to have some people-to-people skills, because you have to always be explaining and encouraging. And honestly, if I was an in-house counsel right now, which I have been in the past, but if I was like a chief privacy officer, what I would be wanting to do is get the top, the leadership, all the way up to the board on board, because privacy can be, and we talk about this, but I see this definitely in the world coming, as a market differentiator. It's not going to be just a cost factor. Like I read an article in the CFO magazine, which is good. They're telling CFOs, get on board. This is here. You better be taking care of it, so you don't get penalized. But I think it's better if the management, the board sees this as a market differentiator, as a positive way to lead the class of the business. And I think, I do think that's going to be coming.
Yeah, the words I've jotted down throughout here are documenting your analysis, cross-functionality, involving everybody, and making sure that you have the right help that you need.
Yes. So yeah, there's going to be, like, obviously first you need that analysis. Are we in, do we have to do a risk assessment? Are we in for the cybersecurity work that we have to do, the ADMT? You need, most companies are probably going to need some outside help to do that analysis. Then they're going to need help, a lot of companies, on the heavy lifting to get the infrastructure going. Once you have that going, like in Europe, they've been what they call the DPIA process, but we're going to have something similar to that for high risk processing. Again, you can train people internally to do that.
One last question that's just popped up. If you have any resources, Jenny, off the top of your head, or maybe this person can reach out to us after, nuts and bolts for writing and reviewing privacy notices.
Yeah, I should write something about that. I've been doing that for a while. I'll just tell you some of my tips. I mean, I am a huge person in favor of the layering approach. Like when I started getting into this in 2017, 2018, because I had B2B clients that were asking me to help them with GDPR. And I'll tell you honestly, in the 2000s, I was a GC, so I did safe harbor for one of my companies. But when I was first going out on my own, I kind of avoided this because I thought tech companies weren't taking it seriously enough. Thank you, GDPR. That changed that. So when I first started working with B2B clients, I started looking at what does the FTC say, because we've had privacy regulation, everybody. It's called the FTC. I mean, Facebook was under this consent decree, Twitter. So I started looking at those, and the recommendations was layering, make it user friendly. Because and this is a good message I think to get across too, is when you are writing a privacy policy, yes, ostensibly it's for your users. You should know them, who they are, and make sure it is. And maybe if you could do a test to see, but you're also writing that for the regulators.
Yeah.
And I expect with AI that the agency is going to be using AI to quickly scan websites and find who's outside of the herd. I call it, and I'm not the only one, I've heard other people call this the herd approach. So there are so many things. I've given talks on this of, like, I've reviewed a group, 20 privacy policies, and just said, here are the things that would be so easy to catch you out on. Like in California, you better have a date and it better be within a year. I mean, there's just so many things that, you want to make sure you've got. But the layering, I practice that. And so, like, my cookie notice, the details of what kinds of cookies and tracking technologies, that's on a separate document. My requirements for CCPA, that's like at least 2 pages, because you've got some very detailed things you need to disclose if you've got these types of personal information. That's a separate hyperlink. It's very easy for a user to find. So those, feel free to, whoever that is, contact me. Happy to chat about it. I teach, so I love talking about this stuff.
Well, we love talking to you about it, Jenny. We're so grateful for your time and thoughtfulness leading into this program and for sharing your expertise with us today. We also want to thank the audience for joining us today. Last but not least, we invite you to check out Paragon Legal, especially our brand new website launched last week. Connect with us on LinkedIn, shoot us a message. We love to talk about how we can work together to resolve your legal support needs, or if you're interested in joining the Paragon team as an attorney. Jenny, thank you so much for your time today. Thank you to everybody.
So much fun. Thank you.
Have a good afternoon.